Today's lesson begins our discussion of the business form of a corporation. We will be spending the balance of the semester talking about corporations. If we have a little bit of time at the end, we might get in a little bit of discussion about securities regulations. Chapter 41 of your textbook talks about the history and nature of corporations. There are three primary classifications of corporations. The first type of a corporation is a for-profit corporation. Most corporations are for-profit. The vast majority of corporations fall into this category. We have a second classification of corporations, and that is a nonprofit corporation. Nonprofit corporations are different from for-profit corporations in two primary ways. Number one, they do not issue stock. And number two, their owners are called members, just like LLC owners were, rather than owners. The final category of corporation is a government-owned corporation. Sometimes government form corporations to do things like run a city or run the gas company. So government-owned corporations are designed to perform government and business functions for the government. The only classification of corporation that we are going to be discussing is a for-profit corporation. And while I hope that a large percentage of you go out and work for nonprofit corporations, because for-profit is the most common corporation out there, that is where we are going to devote our discussion. What are the characteristics of for-profit corporations? First of all, a corporation can range in any size. A corporation can have as few as one owner or have millions of owners, like some of those corporations that are traded on the public stock exchange, corporations like General Electric and AT&T. For the most part, with the exception that sometimes government relaxes the regulation of smaller held corporations, large corporations like General Electric and AT&T are subject to the exact same rules and regulations as a corporation that may have just one owner. In deciding to form a corporation, the incorporators get to pick whatever state they want to incorporate in. They can pick one of the 50 states, and this is true even if they have absolutely no intention of doing any business in the state in which they incorporate. For this reason, over 50% of corporations are incorporated in the tiny state of Delaware. And many of those corporations never end up doing any business in Delaware whatsoever. We're going to talk a little bit later about why this is, why Delaware is so popular. But one of the reasons Delaware is popular is the laws in Delaware tend to be very pro-management and not so pro-stockholder. And generally, it's people who are going to be involved in the management of the corporations that are the ones who are going to undertake the incorporation of the company. So they tend to pick the state like Delaware that has laws that are very pro-management. Delaware's fees and costs are also much less expensive than other states to incorporate in, and that's another reason why people gravitate toward Delaware to form their corporations. Corporations who have very few shareholders and whose shares are not available to the public, so they're not traded on the stock exchanges, are called close corporations. Most corporations out there are closely held for-profit corporations. There is a special type of corporation that is called a subchapter S corporation. A subchapter S corporation is a corporation formed for tax purposes Because if you elect as a corporation to be a subchapter S corporation, you are taxed like a partnership for federal income tax purposes. As we've discussed before, for the most part, it's more favorable to be taxed as a partnership than it is to be taxed as a corporation. So a lot of people find electing subchapter S status for their corporation to be desirable. In order to qualify as a subchapter S corporation under the current laws, there can only be one class of shares of the corporation. We'll talk about classifications of shares later on in the semester, and have 100 or fewer shareholders. Generally speaking, if these requirements are met, most corporation owners choose subchapter S status. As we discussed with respect to the other business entities we've studied, there is a uniform law governing corporations as well, and it is a law that has been adopted in 29 states. The name of the uniform law governing corporations is the Model Business Corporation Act. And because it's been adopted by the majority of the states, that is the act that we are going to be studying. The interesting thing about the Model Business Corporation Act, however, is that there are several important states that have not adopted it. For example, our state of California has not adopted the MBCA, neither has Delaware, and neither has New York. Now, that's important for a couple of reasons. First of all, as you remember, as I said, over 50% of corporations choose to incorporate in the state of Delaware. So the majority of corporations are not governed by the Model Business Corporation Act. Also, for our purposes, since most of you, presumably, if you're going to establish a corporation, at least in the near future, you're going to be established in California. California also does not follow the MBCA. Where the laws of California and Delaware differ from the MBCA, I will do my best to point those differences out to you. Our next topic of discussion is how corporations are regulated. Just like every business entity that we have studied, a corporation is created under state law. There is no federal law governing the creation and operation of corporations. A corporation is always governed by the state in which it chooses to incorporate. So, if you choose to incorporate in Delaware, like more than 50% of the corporations do, you will be subject to Delaware's laws regarding the internal operations of your corporation. Internal operations are things like the responsibilities of the board of directors, the duties owed by management to the shareholders, those types of things governing the internal operations of the company are generally governed by the state in which the corporation incorporates. However, as the economy grew and corporations started doing business in more than one state, other states decided that they wanted to regulate corporations for various reasons. We'll talk about what those reasons are in a little bit. So the question is, when is that okay to do so? When may another state step in and impose its rules and regulations on a corporation that was formed in a different state? In order to guide our discussion on that regulatory issue, it's important to grasp some terminology regarding corporations, because it's not natural to think of these definitions in the context in which they're used when it comes to corporations. So, first of all, a corporation is a domestic corporation in the state in which it incorporates. So if you incorporate in California, you're a domestic corporation in California. If you incorporate in Delaware, you're a domestic corporation in Delaware. In every other one of the 49 states in which you did not incorporate, you are considered to be a foreign corporation. Right? That's where the terminology is a little not what we're used to, because generally when we think about foreign, we think about other countries. But with respect to corporations, foreign means in every state other than the state in which you chose to incorporate. With respect to corporations that are formed in other countries, they are considered to be alien corporations in the other countries in which it does business. Let's assume I'm one of those corporate owners that decided to form my corporation in the state of Delaware. But I have no intention of doing business in Delaware, and I focus most of my business within the state of California. And I make millions of dollars operating primarily in the state of California. Does California have an interest in imposing some of its rules and regulations on my corporation? The answer is most likely yes, for several reasons that we'll talk about in a little bit. When is it okay for a state to do that? When it is okay for a state to impose its laws on a corporation that has been formed in another state? This is an issue under the United States Constitution. Before a state may regulate a foreign corporation, it must pass two constitutional tests. The first test that the state must satisfy is the Due Process Clause. The second test that must be satisfied is the Commerce Clause. And as I said, both of these are clauses found in the United States Constitution. The due process test requires that a foreign corporation has to have sufficient contacts with a state before that state is empowered to regulate it. What constitutes sufficient contacts to satisfy the Due Process Clause has been ruled upon by the United States Supreme Court many, many years ago in a case called International Shoe. The United States Supreme Court said that in order to meet the sufficient contacts requirement of the Due Process Clause, the foreign corporation must have certain, quote, minimum contacts, end quote, with the state such that regulating the corporation does not, quote, offend traditional notions of fair play and substantial justice. A nice, clear-cut standard, isn't it? What does that mean? Minimum contacts such that regulating the corporation does not offend traditional notions of fair play and substantial justice. Not a very clear standard at all, but that is the standard announced by the United States Supreme Court. And this is another example of one of those standards that gives a lot of discretion to judges when they're deciding these cases, because it's a gray area. What offends notions of fair play? What offends notions of substantial justice? No clear-cut definition, but it's the standard we're left to have to live with. When I illustrate the Due Process Clause in my Business Law 280 class, I use the following example. Now, this is an example concerning an individual rather than a corporation, but the test is the same. So, in my hypothetical, I am operating a tire shop within the city of Los Angeles. And I operate entirely on word of mouth. I have a good reputation. Local people come to me to get their new tires, their tires rotated, their flat tires fixed. I don't have to advertise. I don't advertise on the internet. I don't sell on the internet. I just have my shop sign out. I operate based on my reputation within the community. One day, a family comes in asking for new tires on their sedan, and I look at their tires and I agree. They need four new tires on their car. And so they hire me to replace their tires. As I am replacing their tires, I happen to notice that they have a California license plate. And I put on the 4 new tires, I charge them, and I send them on their way. Unbeknownst to me, about a month after I install the new tires on their car, they take a cross-country trip and they move to New Jersey. And while they are in New Jersey, one day on the freeway, one of the tires explodes because it was a defective tire. And the car spins out and the car crashes and does some major damage to the car, and the family members that are inside the car when the accident happens have some serious personal injuries as well. Now this family decides it wants to sue me for the damages to their car and their personal injuries, but they're living in New Jersey. So where is it most convenient for them to bring their lawsuit? In fact, the New Jersey State Court is just 3 blocks from their new home. So, of course, they're going to want to sue me in New Jersey. That's where it's most convenient to them. So they bring a lawsuit against me in New Jersey. And one day I'm working in my tire shop in Los Angeles. A process server comes to the tire shop, knocking on the door. Professor Flügge? I say yes. And the process server drops the papers at my feet and says, "You've been served." I pick up the package, I open it up, and I see that inside the package is a summons from the State Court of New Jersey commanding that I appear in New Jersey to defend the lawsuit that's been filed against me. So the question here is, can the state of New Jersey require me to travel to New Jersey to defend a lawsuit that's been brought against me there? And this is a question that is analyzed through the Due Process Clause of the United States Constitution. Because before the state of New Jersey can require me to come before its courts and subject myself to its jurisdiction, I have to have sufficient contacts with New Jersey so that notions of fair play and substantial justice are not offended. So in that scenario, the court is going to say, what contacts has Professor Flügge had with the state of New Jersey? When I sold the tires, I sold them in Los Angeles. When I sold the tires, I had no idea that this family was going to be moving to New Jersey. I saw their California license plate. I assumed that they were going to be California residents. And I've never even been to the state of New Jersey. I have no intention of ever going to the state of New Jersey. So what are the contacts that I've had with the state of New Jersey? Under that scenario, it is most likely that the court in New Jersey is going to dismiss the lawsuit, finding that if they forced me to come to New Jersey to defend that lawsuit, I would not have sufficient contacts with the state and it would offend the Due Process Clause. The other example I give in contrast in my Business Law 280 class is, now assume that I'm running that same small owned tire shop in the city of Los Angeles. Again, I need no advertising, just go based on my reputation. And my husband, who's running the tire shop with me, decides to run off with his new young girlfriend and abandon me and abandon our children. And he takes his new young girlfriend and they move to the state of New Jersey. Oh, I am so mad at that guy. To add insult to injury, every month when he's supposed to send me a child support check, he never does. I have to chase after him month after month after month to get him to support our children. And the more I think about this as I'm working alone in my tire shop, is how I want to get back at that guy. Then I find out my husband and his new young girlfriend have opened their own tire shop in New Jersey, taking everything I taught him about running a tire store and setting up a new store with his new little girlfriend. So I decide I want to take out my revenge. First thing, I find out that right above my husband's new tire shop that he runs with his new little young girlfriend is an empty billboard. Oh, I come up with a great plan. I take out an advertisement on that billboard that says right above his tire shop, the owner of this tire shop is a lying, cheating child abandoner. And then I put a nice big red arrow pointing down right at his tire shop. Oh, I'm feeling a little bit better already. But not quite all the way better. The next thing I find out is that in the town in New Jersey where he set up his shop, there is a trade publication for auto parts suppliers, auto parts, tires, service shops. And that trade magazine circulates within the auto community. So I decide I'm going to take out an advertisement in that trade publication. Right? And I take out a full page advertisement. And my advertisement says, I just want to introduce you to the newest tire shop owner in your town. And then I unload on him. I said, this guy left me for his new younger girlfriend. Right? He abandoned his children. He took all of my great ideas for running a tire shop and he set up a store in your town. Is this the type of person you want to give your business to? Question mark, question mark, question mark. And when my ex-husband sees the billboard and he finds out about the trade publication, he brings a lawsuit against me, also in the state of New Jersey. Right? Defamation, interference with prospective economic advantage, whatever causes of action he can think of. Now that same process server comes to my door at my tire shop in Los Angeles, knocks on the door, Professor Flügge, right, drops the packet at my feet, you've been served. Now I open up that packet and I see a subpoena from the New Jersey State Court commanding that I come to the state of New Jersey to defend the lawsuit my ex-husband has brought against me. Under those facts, does the New Jersey court have the power to compel me to appear in that lawsuit and subject myself to any judgment that might be issued against me? And again, this would be analyzed under the Due Process Clause. And the question would be, do I have sufficient contacts with the state of New Jersey that it is fair for it to force me to come to defend that lawsuit? And I make the same argument that I did with respect to the family that I sold the tires to. I say, hey, I'm just working here at my tire shop in Los Angeles. I have never been to New Jersey. I have no intention of ever going to New Jersey. You should not have the power to force me to defend this lawsuit. In this second lawsuit, chances are the result is going to be different. Because the court in that situation is going to say, even though I did not physically come to the state of New Jersey, I do have sufficient contacts within the state in order that it's fair that I have to come and defend the lawsuit there. And there's several contacts. Right? First of all, I entered into a contract with the billboard company to take out an advertisement in New Jersey. Secondly, I entered into a contract with the trade publication intending that it circulate within the state of New Jersey. And finally, the person that I intended to hurt with my actions is now a resident living in New Jersey, so I intended to hurt him in New Jersey. So most often in that case, under those types of facts, the court will find sufficient minimum contacts that I will have to go and defend that lawsuit in New Jersey. The due process clause is only one of two constitutional tests that must be met. And these are completely different tests. The second constitutional test that must be satisfied before a state may regulate a foreign corporation is the Commerce Clause. In order to understand the Commerce Clause, we have to talk about two different terms, and once again, they're very close sounding, but they have two very different meanings. The first term is interstate commerce, interstate, which is business conducted between two or more states. The other term is intrastate commerce, not inter, but intra. Intrastate commerce is business that is conducted within one state. The reason these terms are important is because under the Commerce Clause of the United States Constitution, the power to regulate interstate commerce is given solely to the federal government. So business that's being conducted between two or more states can be regulated only by the federal government and not by the states. What does that mean? All right, let's say we have a truck that's leaving from New York State and traveling to the state of California. And on its way, it stays on interstates, which are roads maintained by the federal government, owned and maintained by the federal government. When that truck is driving through the state of Kansas, can Kansas put a toll road up on the interstate and ask the trucking company to pay a fee to continue on through that state to get to California? And the answer to that is no, because this truck is engaged solely in interstate commerce. Even though it's traveling through Kansas, it is traveling through on federally owned and operated roads. So Kansas has no right to try to impose itself in collecting fees or imposing any kind of regulations on that truck. But now, let's assume when that truck is passing through Kansas, it exits the interstate and it starts driving on Kansas-owned highways, state-owned highways. And the truck driver stops, it fuels with gas, it stays overnight. The truck driver stays overnight, he eats some meals there. In this case, when the truck driver pulls off the interstate and goes onto the state highways and purchases goods within the state of Kansas, that portion of the business that the trucker is conducting is intra-state business, business solely within the state of Kansas. When a foreign corporation engages in intra-state business, business within a state, the state may regulate the corporation only if it meets 3 tests. First, whatever regulation it wants to impose on the foreign corporation serves a legitimate state interest. Second, the state has chosen the least burdensome means of protecting that interest. And third, the legitimate state interest is so important that it outweighs whatever burden the law places on interstate commerce. All 3 of these elements must be met in order for the Commerce Clause test to be satisfied. So number 1, the law must serve a legitimate state interest. Number 2, the state has chosen the least burdensome means of promoting that interest. And number 3, the legitimate state interest outweighs the law's burden on interstate commerce. Let's see an example of this. The state of Pennsylvania passed a law that imposed a $25 flat fee on all trucks that had not registered in Pennsylvania. So a New York truck, a New Jersey truck, an Ohio truck, any truck not registered in Pennsylvania that traveled on Pennsylvania highways, and again, these are state-owned roads, had to pay a flat fee and get a little sticker they placed in their truck. And the purpose of this fee was to pay for damage to the state-owned highways that were caused by heavy trucks driving on those highways. Studies show heavy trucks do much more damage to roads than do automobiles. A trucking company that was subject to this $25 flat fee claimed that the state of Pennsylvania was violating the Commerce Clause by imposing it. And this is a case that went all the way to the United States Supreme Court over a $25 flat fee that was being imposed on its trucks. The United States Supreme Court, in order to decide whether the state of Pennsylvania could impose this law on a foreign corporation, the trucking company, had to engage in the 2 constitutional analyses that we've been talking about. In the first case, it would be an analysis under the Due Process Clause. That one's pretty easy. These trucks are traveling on Pennsylvania highways. That is sufficient contact with the state to satisfy the Due Process Clause, right? The physical presence within the state. But with respect to the Commerce Clause, the court had to apply the 3-part test that we've just talked about. The first question for the Supreme Court to decide was, did the fee serve a legitimate state interest? And in this case, the United States Supreme Court said yes. Raising revenues to repair state highways from the damage done by heavy trucks was a legitimate state interest. So the law was passed to promote something that the state was legitimate for the state to promote. The second question is, was this $25 flat fee the least burdensome method that the state of Pennsylvania could use to promote its interest of protecting its highways? And this is where the Supreme Court found a problem with the law. The Supreme Court said the flat fee did not take into account how much traveling on the Pennsylvania roads these trucks did. If you entered the highway one time, once a year, you were required to pay this $25 flat fee. In contrast, if you were on Pennsylvania highways 365 days a year, you were required to pay the same flat fee, even though you were doing probably 365 times more damage to the highways. So the U.S. Supreme Court held that because Pennsylvania had not adopted a fee that took into account the actual damage being done to its highways, it was not the least burdensome means of protecting the integrity of its state highway system. And for that reason, the court found that this fee violated the Commerce Clause and overturned the requirement that the truckers had to pay this flat fee. Now, Pennsylvania was free after this to come up with a law that took into account how much traveling was actually being done on its highways. And if it had some reasonable way of measuring that and varying the fee that it charged based on that difference, then that is something that would pass the Commerce Clause. But in this case, because it just imposed this flat fee across the board, the U.S. Supreme Court struck it down. We've talked about the two constitutional tests that a state has to satisfy in order to regulate a foreign corporation. But now we're going to ask, why might a state want to impose its regulation on a corporation that was established in another state? There are several reasons, but they basically break down into two categories. Number one, revenue reasons. The state wants to get some money out of the foreign corporation's operations. And the second reason is to protect the state's residents from damages that the foreign corporation might do to them, or harm that the foreign corporation might do to them. Revenue reasons. Let's take my example where I incorporated in Delaware, but I've never conducted any business in Delaware. I've conducted the vast majority of my business in the state of California. And I've raised millions of dollars doing so. Does the state of California have an interest in wanting to take some of the revenue that I've earned by operating in its state? And the answer is, of course it does. It doesn't want me to take advantage of state resources, state residents, without having to make some contribution to the state tax revenues. So taxation is a big reason why a state may want to regulate a foreign corporation. And taxation can take several forms. Number one, if I own property within a state, the piece of real estate, the state might want me to pay a property tax. Number two, if I earn a lot of money within that state, the state might want me to pay a state income tax on my revenues. And finally, and very recently, there's been an interesting concern about states wanting to require foreign corporations to withhold sales tax on sales made within the state and to remit that sales tax to the state. I don't know how many of you remember the days when you used to be able to make a purchase on Amazon. And if you were buying from a seller outside the state of California, Amazon did not charge you any sales tax. And the fact that the internet seller, in this case Amazon, wasn't charging you sales tax didn't relieve you from your obligation to pay the tax. What you were supposed to do is, with respect to purchases made in other states, you were supposed to, when you prepared your tax returns, submit those sales taxes to the state where you made the purchase. You can imagine how many people actually did that. Very few, if any. And every time, for example, in California, when you send in your state income tax return, you were supposed to have something on your state income tax return that said, I made these many internet purchases in California without paying sales tax. And you were then supposed to remit the sales tax to the state. Well, of course, most consumers didn't do that, and this created a huge problem for the states who were used to having lots of sales revenues when people went to brick and mortar stores and bought their purchases. Because when they went to a brick and mortar store, that store was required to charge you the sales tax and to remit it to the state. The more and more purchases that were being made on the internet, the more sales tax revenue the states were losing. So the states wanted to require foreign corporations that made sales within their state to charge the sales tax and remit it to the state, just as if that foreign corporation had a brick and mortar store and was doing those sales within the state. The rule used to be that before a state could do that, a physical presence of the foreign corporation was required within that state. It needed to have a warehouse or a distribution center or some kind of physical presence. And that was a rule set out by the United States Supreme Court. Many states were upset with this rule because a lot of internet sales were being made by foreign corporations within the state that did not have any kind of a physical presence. So, a law was passed in the great state of South Dakota, my great state of South Dakota, that despite the Supreme Court rule saying that a physical presence was required, South Dakota passed a law requiring sellers who delivered more than $100,000 worth of goods in the state, or who engaged in 200 or more separate transactions, to withhold sales tax from its sales made within South Dakota and to remit those sales tax to the state. And this case involved the internet company Wayfair. And Wayfair challenged South Dakota's law. And they said, you can't force us to do this, state of South Dakota, because we don't have a physical presence in your state. The case went all the way back up to the United States Supreme Court. And the United States Supreme Court overruled its earlier case, the case of Quill, which required a physical presence, and said, given the realities of the internet these days, we are no longer going to require a physical presence before a state may require that an internet seller charge and remit internet sales tax. So this is a new case. This is a case that was decided in June 2018, and it's so recent it hasn't made its way to your textbook. So your textbook is out of date at pages 1120 to 1122. Those portions talk about Quill and the requirement of having a physical presence. That is no longer good law. The new law is, at least the way South Dakota set up its law, which required more than a trivial amount of goods being sold. And it set a standard. It had to be at least $100,000 worth of goods or a certain number of transactions. Those laws will now be upheld, even in absence of a physical presence within the state. The second reason a state may want to regulate a foreign corporation is for the protection of that state's residents. For example, the state may want to require a corporation to appear in the courts of that state if a resident of the state sues the corporation. A second way that a state tries to protect its residents from the business of a foreign corporation is requiring the corporation to do something called qualifying to do business. If you do enough business in a state, and this is true not only of corporations, but other business entities as well, the states may require you to go through a procedure to authorize you to be doing business within that state. Again, intra-state business. And the procedure for qualifying to do business is basically the same state by state. Number one, the foreign corporation has to apply to the Secretary of State for a certificate of authority. It must pay an application fee. And the third thing it must do, and this is what is really intended to protect the residents of the state, the foreign corporation must maintain a registered office within the state and must identify a living person with the person's name and address who is authorized to accept service of legal process on behalf of the foreign corporation. So, if you want to serve a lawsuit on the corporation, you don't have to go chase it down in some other states and try to find out where its main office is or who's authorized to accept service. They are required to designate someone within your state who is authorized to accept service of complaints, service of summons, and when you serve that person, the corporation is deemed to be served, making it easier for the residents to find the foreign corporation and require it to respond to a lawsuit. Finally, the fourth requirement in order to qualify to do business is that the foreign corporation must file an annual report and pay an annual fee. So, requiring a corporation to qualify to do business is kind of a combination of a revenue source through the annual fees and also the protection of its residents. The fourth reason that we've talked about why a state may want to regulate a foreign corporation is in order to be able to regulate the internal affairs of the corporation. If you remember at the beginning, usually the state that is authorized to regulate the internal affairs of the corporation is the state in which the corporation was formed. So the domestic corporation, the state of a domestic corporation, is the one authorized to regulate its internal affairs. There are some states, and California in particular, who do not like this. And the reason they don't like it is because of all of the corporations who intend to do their primary business in the state of California, but who choose to incorporate in a state like Delaware that is much more pro-management and much less favorable to shareholders, particularly minority shareholders. California is very protective of minority shareholders in a lot of its rules and regulations that we'll study later on. So we have something of concern to states like California that are with respect to what are called pseudo-foreign corporations. Pseudo means fake. So they're saying you, corporation, are technically a foreign corporation because you chose to incorporate in another state, but you're doing the majority of your business here. So we're going to call you a fake foreign corporation. Right? You're just relying on a technicality. So a pseudo-foreign corporation is a foreign corporation that conducts most of its business in a state other than the one in which it is incorporated. In the instance of California, California imposes its regulations on the internal affairs of some of these pseudo-foreign corporations. In California, corporations that have more than 50% of its business and ownership in California are subject to certain of California's laws that are intended to protect minority shareholders and also the creditors of the corporation. Laws that are different than the laws in the state of Delaware, for example. Not surprisingly, laws like California's are very upsetting to the state of Delaware. Because if other states are going to come in and regulate its domestic corporations, Delaware's domestic corporations, and impose more stringent requirements on it, then why incorporate in Delaware in the first place? Delaware wants to keep its advantage of being very favorable to management, to try to get businesses to incorporate there. So not surprisingly, the Delaware Supreme Court has held that California's law is unconstitutional. But does what the Delaware Supreme Court say have any weight here in California? No. Right? Delaware State Court can't say what's constitutional or not as far as what California does. Right? But they have rendered that decision. At some point, some way, the issue was probably going to go up before the United States Supreme Court. May California impose its rules, laws, and regulations on a corporation, on the internal affairs of a corporation that was incorporated in another state? And if and when that question reaches the United States Supreme Court, the United States Supreme Court is going to have to go through the same constitutional analysis that we've discussed during this lesson. Number one, does California's law satisfy the Due Process Clause? In this case, the answer is probably yes, because California only imposes its law on foreign corporations that do more than 50% of its business in the state and have 50% of its owners living in the state. So that's certainly far more than minimum contacts with the state. So the Due Process Clause undoubtedly is satisfied here. The real question is going to be, does California's law run afoul of the Commerce Clause? And the United States Supreme Court is going to have to go through these three-prong analysis for whether or not a law satisfies the Commerce Clause. In the first instance, the court would have to decide whether California law serves some legitimate state purpose. And the answer is probably going to be yes. Right? Protecting minority shareholders, many of whom probably live in California, and creditors, many of them who are probably California residents, that's a legitimate state interest that California has. Secondly, has California chosen the least burdensome means of promoting that interest by imposing this law and regulation? I think the answer to that is probably going to be yes as well. I can't think of any other way that California can protect its minority shareholders and creditors other than imposing its laws on these pseudo-foreign corporations. The real question is going to come with number three, I think. Does California legitimate state interest in protecting its minority shareholders and creditors outweigh the burden that its laws place on interstate commerce? And here's why I think that might be an issue for the United States Supreme Court. If you are a corporation incorporated in Delaware, and you conduct at least 50% of your business and have at least 50% of your ownership in California, whose laws do you look to decide how your internal affairs are supposed to be operated? Right? Delaware's laws are different than California's laws. Now, the answer to that might be, well, you have to comply with the more stringent laws, and the more stringent laws are California. But what happens if there's a conflict between the two laws? Then the owners of the corporation aren't going to know how to conduct its affairs. And what happens if other states start looking at what California has done and they decide they want to impose similar regulations on foreign corporations that do business in their states? Right? And maybe they decide it doesn't need to be 50% of their business. Maybe they decide it's just if you do 25% of your business, we want to regulate your internal affairs. So let's say we have a corporation incorporated in Delaware that does 50% of its business in California and 50% of its business in the state of Washington, or excuse me, 25% of its business in the state of Washington. And Washington has imposed a similar law. Right? Now the owners of the corporation are potentially subject to regulation by Delaware, California, and Washington over how its internal affairs are supposed to be conducted, and those laws may not agree. So the chaos that may ensue from the Supreme Court upholding these types of regulations of pseudo-foreign corporations might impose more burden on interstate commerce than the legitimate state interest. Right? The burden imposed on interstate commerce is more than these states' interests in regulating these foreign corporations. But we won't know the answer to that until the issue ever reaches the California or the United States Supreme Court. So the last thing I want to do before I leave you is to address the one case that was assigned for briefing today, which is the Drake case. Drake involved a claim that Drake, that was a foreign corporation in the state of Pennsylvania, did enough business in Pennsylvania that it was required to qualify to do business within that state. Remember, one of the regulations that states want to impose on foreign corporations, but that although it had been required to do so, it had not done so. One of the ways that states try to enforce the obligation to become qualified to do business is by passing a law that says if you do not qualify to do business, you may not take advantage of our court system by suing people within our courts unless and until you've complied with your obligation. It's kind of a way to make sure that eventually these businesses come into compliance, because when they want to bring a lawsuit, they have to go through the steps of qualifying to do business. So Drake Manufacturing was incorporated in Delaware, like a lot of businesses do, doing business in Pennsylvania where it was a foreign corporation, but it had not qualified to do business in the state of Pennsylvania. Because it had not qualified to do business, it was not authorized to bring a lawsuit unless and until it complied with that requirement. The defendant in this case, Polyflow, owed Drake nearly $300,000 for materials it had purchased from Drake but had not paid Drake for. So Drake sued Polyflow in the Pennsylvania courts, where it was required to do so because Polyflow Inc. did its business in Pennsylvania. Polyflow had absolutely no defense whatsoever to the merits of the lawsuit. It owed the $300,000, it hadn't paid it. The only defense that it asserted in the lawsuit was that Drake Manufacturing had been obligated to qualify to do business, had not done so, and therefore was obligated to qualify to do business before it could proceed with the lawsuit. And rather than qualifying to do business, Drake Manufacturing was stubborn, and it argued to the court that it did not do enough business within the state that it was required to qualify to do business. And it succeeded with that argument before the trial court. The trial court agreed, said all it was doing was trying to enforce this obligation. I think the trial court felt like Polyflow owed the money. So the court entered judgment in favor of Drake against Polyflow. Polyflow appealed to the Court of Appeal and made the same argument, that I have no defense to the merits of the case, but Drake did not have the legal right to bring that lawsuit because it did not qualify to do business in Pennsylvania. And the Court of Appeal agreed with Polyflow. They said that Drake did a sufficient amount of business within the state of Pennsylvania that it should have qualified to do business. Because it had not, the Court of Appeal reversed the entire judgment and also said it was now too late for Drake. It couldn't, after trial was concluded, comply with its obligations to qualify to do business. It had to do it prior to the time it brought the lawsuit, or at least before judgment was entered. And because Drake had been stubborn in its position that it didn't need to, when the Court of Appeal ruled this, Drake lost the entire $300,000, even though Polyflow had no defense on the merits. So, a great illustration of the risk of not qualifying to do business in another state when you are obligated to do so.